Let's take a look now at a professional responsibility question from July 2010. It's question 2. And remember, the right mindset. Take the right mindset into the exam. What's the right mindset for essays? There's 3 parts. If you've heard me say it along with me or skip ahead a minute into the actual substance. If you hadn't heard me say it, here it is. 3 parts. 1, do you understand what's going on here? Do you understand the situation? Approach the bar exam as if you're already an attorney, because you are. You're just demonstrating here's how an attorney thinks. Right? You're not a student becoming an attorney, you are an attorney. What does an attorney do in real life? They take a client situation and they go, okay, let me step back. Do I understand what's happening? Right? There's a common sense aspect to what's happening, and there's a legal sense of what's happening. That's what you have to do. What's going on here? What's the common sense? What's the situation? What's the legal sense? Now, once I understand what's going on with the situation, could I have a conversation about this with another lawyer? All right, so I'm sitting down to lunch with another attorney and we're chatting about this particular case, and I say, yes, I actually wanted to discuss this aspect of the case, and there's these 2 particular facts that are troubling me, but I know that there's an exception in the rule that where we might be able to advantage our client this way. On the other hand, if the opposing, you know what I'm saying? Can you have a conversation about it? Because if you can have a conversation about it with another attorney, then you know what you're doing, you know how to talk about it, and you could write this. If you can do part 3, which is organize your discussion on paper. So that's the 3rd part, right? How do you get that conversation you would have with another lawyer about all the contours of the case? How do you get it on paper? And that's where practice comes in. So 3 parts of the mindset. 1, do you understand the situation? 2, could you have a conversation about it with another lawyer? 3, can you get that conversation in an organized written format? If you can do that, you're going to pass the question. Let's get into the question. What was happening in this case? What's the situation? Okay, well, we have 3 people, Owen, Fred, and Hap. Who are they? Well, happens to be that this guy named Owen is a wealthy person who owns a piece of property that was formerly owned by a guy named Fred, and that has hazardous waste on it that was apparently put there by a guy named Hap. All right? So what happens? Who do we care? Well, because the city comes to the 3 of them and says, hey, we know that there's some hazardous substances coming from this waste disposal site that you, Owen, own, and you, Fred, used to own, and you, Hap, you're the guy that put it there. And guess what? We're going to sue you guys if you don't clean it up. So you got 2 choices. Clean it up or pay the cost to clean it up. That's what you got to do. Okay, fair enough. And the city says, yes, and here's how much culpability each of you have. Here's how responsible each of you are. And if any one of you doesn't pay, guess what? You're all jointly and severally liable. So one of you is getting stuck no matter what. Okay, well, if we step back and we think common sense, okay, if I'm the wealthiest person, I might think, given that I might be holding the bag anyway, I'm going to go ahead and pay for representation. I'm inferring that. That didn't happen. I don't know. But look at it. What happened? Owen steps in and he says, hey, listen, guys, I'm going to pay for the representation of the whole thing, but I want you to agree to let my lawyer, Ann, handle it. They say, okay, that's fine. Let Ann handle it. Now they go to Ann, and Ann it distributes identical retainer agreements to all of them, and they all sign. Okay, so these are the basic facts. This is what happened. Well, what's the problem? What's going on here? Well, now we're having a conversation with another attorney at lunch. And I don't care which side you're on, but you're thinking, you know what? This rich guy who owns this lot is going to pay for representation, and he got everybody to sign an agreement, but, the lawyer is a tax lawyer who's representing an environmental cleanup issue, and there's no mention of disclosing conflicts of interest. In other words, you get into the universe of it. Now let's break it down. All right? I hope that helps you to kind of get in the mindset of what we're about to do. The breakdown, I think, will complete your thoughts. How do we break it down? At this point, if you haven't already read the answers, stop the video and go and read both answers. Read both of them, because I want you to understand the different ways of laying this out. All right. The first answer starts with loyalty. The second answer starts with competence. They both are published answers. They obviously both were exceptionally bright, students, and they passed obviously, right? So it doesn't matter the chronology of these particular issues, but I want you to get a sense of different ways that you could do it, because I want you to be fluid in the way you answer these questions and not so robotic. At the same time, I want you to have structure. Here's the structure I want to present. First issue, competence. Why am I going to say that first? For me, it's the easy one. This is the juicier issue because there's more going on, as you can see. But competence, it's easier. Why? Because Ann's a tax attorney, and what kind of case are we dealing with? We're dealing with a case of environmental cleanup. Is she competent to do that? I don't know. What's the rule? What's the rule for competence? What is it? The rule is that an attorney must have the legal knowledge, skill, thoroughness, and preparedness that's reasonably necessary in order to represent this particular client. If they don't have that knowledge, then they can either A, go out and get it by studying, taking a course, or 2, associate with an attorney that does have that. What happened here? Ann's a tax attorney. Off the bat, does she have competency in dealing with a hazardous waste case? No. Okay. So she has one of 2 options, study or associate. Did she go and study? No. Doesn't say so. Did she associate with another attorney who's skilled in the area? No. Didn't say so. Okay. Did she violate her duty of competence? Yes. Because she didn't follow the rule. Cut and dry. Very simple issue. I think it's a great place to start. Get your mind going, get your fingers moving, and you're in. That's my thoughts. Now, the big issue, loyalty. Loyalty and conflicts of interest. Now, loyalty can be broken down a lot of different ways. I think you should keep it somewhat, keep it simple, but bracket out enough to where a grader can see that you've touched all the key points. The major rule of loyalty is what? And notice I've gone ahead and put conflicts of interest right up here, and then I've noted actual and potential conflicts, and then we'll get to the sort of exceptions of how you deal with that in a moment, and then the important facts. What's the general rule of loyalty? The general rule of loyalty is that a lawyer must be loyal to his client and cannot take on representation if his own interest or the interest of a third party will limit his ability to make sound legal judgments. There's a couple different ways that you can write that rule, but that's the essence. If I represent Owen, who's my client, okay, am I going to be able to faithfully represent Fred and Hap, who are also my client? I don't know. Is there going to be something that's going to impair my ability to make sound judgments for one or the other, or to advantage one over the other? That's the basic idea of loyalty. So here, I've kind of given you the facts at the same time. You lay out the rule, and then the facts here is that, hey, Ann has taken on concurrent representation of all these 3 people, and all 3 of them are being sued by the city. You might say, well, it's really not going to be a problem because they're all being sued at the same time, so there's nothing that could really happen. And then you could say, on the other hand, there actually may be conflicts of interest, and if there are certain procedures she has to go through in order to keep the case. Something like that. Keep it simple. But that's the setup. Now, actual and potential conflicts. There's the ABA rule and the California rule are similar. The first thing is that the ABA really only deals with actual conflicts. California adds potential conflicts to the mix, to where we now have to go through this procedure of getting consent, and I'm going to go through that because I want you to think for a moment. All right, so we have an actual potential conflict. If we have an actual potential conflict, what do we have to do? Well, number one, the lawyer has to reasonably believe they can take on the representation and maintain loyalty to the client. 2, what's the second one? If the lawyer reasonably believes that they can take the representation, they then have to get informed written consent, which means they have to have a conversation with the client. They have to say, here's the potential conflict, or here's the actual conflict. I think I can represent you fairly, and I think I can take, advantage your interests, but this is the issue. Do you consent? That's the informed part, and then the consent would be, okay, sure, and then in writing. So informed written consent, that's the ABA. The lawyer reasonably believes they can take the case, handle the case, and they get informed written consent. What's different about California? California actually doesn't require informed written consent. It only requires written disclosure. So the lawyer would say, look, we've got these potential conflicts. It may be an actual conflict. Here's what's going on. They've written consent. Okay? Written disclosure. Now, in this scenario, what are the two big things we got to deal with? There's two huge facts. One is the one that's right in front of your face, which is that it's joint clients. Anne is taken on representing all three of these clients. So it's joint representation. So let's talk about that. But also notice that you might forget the fact that Owen is her former client, or even her current client, I guess you could say. It's also her current client. But in this context, she has a pre-existing relationship with Owen. So I would bracket that out and say, you know what, there's a whole other issue. What is that about? What do you mean? I mean that the factual scenario under joint clients would be something like this. The three of these people are being sued by the city, and they might have different levels of culpability, as it said in the facts. One of them might want to push on the other in a litigation and say, you know what, it's not really my fault that I owned it. Fred says it's more Hap's fault that he did it. And Owen might say, yeah, except for, Fred never really told me about it. And even though I should have known about it, I didn't know about it. So since he didn't tell me about it, now I'm going to want him to pay more. Do you see? That's the common sense. It's not in the facts. There's nothing in the facts about them fighting about the degree of liability. But that would make perfect sense that would happen in a joint representation of three people that are being sued by the city at the same time. You get me? So that's the factual discussion right there. So what now? Well, there's a conflict. There's a potential conflict. It could be actual. What does the lawyer have to do? Anne would have to, assuming she was competent, she would have to say, look, guys, I reasonably believe I can take care of you. I think I can make good arguments on all sides. But at the same time, I need you to know what the conflicts are, and I need your informed written consent. Did she get that? What does it say? What does it say here? It says, Anne distributed identical retainer agreements to each of them, which they signed. It doesn't say anything about what was in the retainer agreement. It doesn't say there was a conflict waiver letter attached to it, so we can assume she didn't do it. So did she violate her duty of loyalty in this situation? Yeah. Did she give written disclosure under California? No. Did she violate loyalty? Yeah. There it is. That's the whole analysis. And that blends the legal and the common sense mindsets. Former client. Well, what's the difference? Well, Owen is a sort of special situation because in the joint client context, all three of them need to sign conflict waivers. But in addition, she might need to say to Owen, look, as my former client, I have an additional duty to you, or there's an added duty of loyalty, or an added risk of a breach of loyalty because of my previous relationship with you, so I need to make sure you understand that as well, and then I need you to provide informed written consent, etc. Does that make sense? If you just catch those issues and discuss in a reasonable way and apply that law, you're good. Remember, these answers are 90s and 100s, according to reputable authorities that have graded them. Or given a numerical valuation to them. So if you've got the basics, you're fine. Let's move on. Confidentiality. This is a little bit of a hidden issue to a degree because there's nothing to give you an indication that confidentiality was breached. But look, if you are an attorney representing multiple clients, you have to address confidentiality of the information that flows between you and each client. Well, what do you mean? Well, what is the rule of confidentiality? What's the rule? The rule of confidentiality says that an attorney may not reveal to any third party any information related to the representation unless an exception applies. You can't tell other people about your client's information unless there's an exception. Well, who would be the other people and who would be the client? Well, if Anne takes on all three clients, she's got an attorney-client. This is attorney-client privilege is different, but she's got attorney-client relationship with Owen. She's got one with Fred, and she's got one with Hap. So every conversation she has with each of them as an individual is confidential vis-a-vis the other two. The other two aren't allowed to know what she says unless an exception applies. And what would the exception be here? Well, it's not a crime fraud exception. What's the other big exception? Consent. Consent. If the client gives consent that you can reveal their confidences, then it's not a problem. This is a moment in the context, let's say, of a husband and wife, and you're going to draft a will or a trust for them. Well, you have them sign a consent form that says, I understand that you're my attorney and you're my attorney, and we're all going to talk together as the three of us, so it's okay if we share information. It's the same idea. Here, Anne is the attorney for Owen, Fred, and Hap, and she wants to have a roundtable conversation with all three, so she gets consent from each one of them. No problem. No problem. Except for a big problem. What does it say in the facts about that? Does it say that she has any kind of a consent agreement that would waive the confidentiality issue? No, it doesn't. Therefore, she probably has violated her duty of confidentiality. And that's how you want to talk about it. The facts don't say that she got a waiver or a consent waiver, and therefore, by necessity, she's going to be talking to all three of them, or likely to, and now we have a problem. So conclude there. Now, the other big issue was the financial duties with regard to Owen paying for the representation of everyone. Okay? What's the problem? And then there's these two minor issues. But what's the problem here? The problem is that you cannot, as an attorney, you cannot allow a third party to pay the fees for you to represent another client. Why not? Well, because what could happen there? Go back to common sense. What could happen? What's the problem? The problem is the attorney has a duty. It's kind of like loyalty, although it's in financial duties. It's the attorney has a duty to align their own interests with the client. They can't let any third party influence their professional judgment with regard to representing their client. So if you got a third person paying you, then the third person might have influence over your professional judgment, and you might not be able to do a great job for this client or a competent job for this client. Okay? So the rule is basically that you cannot allow third parties to pay for your services in representing another person unless three things are present. And those three things are that, number one, it will not interfere with your professional judgment. Number two, your client knows about it and consents, so informed written consent. And three, you keep client confidences. So if you step back and you think, well, that makes a lot of sense, because as a lawyer, I got to represent this person. This person's paying. I shouldn't do it, but I can probably get around that if I follow these procedures, which is I say to this person, listen, you can't influence me. Okay? Number two, I tell the client, look, this guy's paying. It's not going to influence me. Do you consent in writing? Yes. Okay? And number three, you can't third-party pay, or you can't know anything about what I'm doing with the client, so no confidential information escapes. That's the rule. Fair enough. What's the facts? What's going on here? Anne is representing all three of these people, and yet only one of them is paying. So, what's the concern? The concern is that she's going to want to do more for Owen. She's going to listen more to what Owen has to say. If Owen wants to shift the litigation or kind of adjust how things go, she might want to do that. Okay, well, that's not a problem if she says to the other two, to Fred and Hap, hey, listen, Owen's going to pay, but it's not going to interfere with my professional judgment. Do you consent, and do you agree to waive confidences? Because she would probably have to do that, yeah? Do the facts say that she did that? No. Because the facts only say that Owen said, agree to let Anne do it, and Anne had them all sign a retainer agreement. That was the exact same thing. It says nothing else. She probably violated this. Those are the big issues. If you got that, I think you passed the question, no problem. These other two, if you even look at how they were written in the published answers, they're pretty minor. So what are we talking about here? Well, fee agreements generally, there is a retainer agreement here, so it's reasonable to discuss fee agreements. The basic idea is that a couple pieces. One, under the ABA, fees must be reasonable. Under California, they must not be unconscionable. You might mention that. There's no mention as to the amount of the fee, so we don't know if there's a violation, but it just shows legal knowledge. Secondly, fee agreements under the ABA do not have to be in writing, but in California they do have to be in writing unless it's the work is under $1,000 or there's a corporate client. Here, this is not a corporate client, number one, and number two, this is probably going to be more than $1,000. So that's again just demonstrating legal knowledge, and then you just open up the fact that none of that was discussed, and you can conclude that perhaps the fee agreement, I think you should just say the fee agreement problem is probably not an issue, assuming that she followed sort of a standard protocol in drafting the retainer. And then communication. Again, there's no issue, there's no facts about communication, but if a settlement offer comes in from the city or information comes in about how they're going to handle it, she's got to communicate with all three of them. And why is that interesting? Well, who does she call first? What does she say to that person? Does she modify what she's not going to say to the other two? So if she calls Owen first, who she's probably going to because that's her client, and he says, okay, well, let's do this and this, does she now communicate the exact same thing to the other two, or does she change it? And so communication, I think, can be an issue given this scenario, although facts are not given to us as to exactly, what did or didn't happen. So that's basically how you want to structure and discuss this. You could structure it differently. The published answers are structured a little differently, but that's not the key. The key is, do you understand what's going on as an attorney? You are an attorney. Could you have a conversation with another lawyer about it? And can you write it down in a coherent, sort of orderly way to where if another attorney picked it up, they could read it and say, yeah, this makes a lot of sense. I can see that argument. Yep, okay, that conclusion makes sense. Boom. That's your job.